Congratulations on becoming part of the Matchbox family. Our entire team welcomes you, and we appreciate the opportunity to serve you this year. We are looking forward to showing you that signing a lease with us is not just a transaction, but a relationship.
And with that being said, we want you to be comfortable with the lease that you are signing, so we have created this leasing video to help guide you through the process. After viewing the video, please don't hesitate reaching out to one of us for any questions that you may have on it.
This is a review of the Matchbox Realty Management Services, Inc. lease agreement. This is a legally binding contract, and you should consult independent legal counsel if you have questions prior to signing. Page 1 is a summary of your lease. The effective date of the lease is the date that the lease is fully signed by both landlord or agent and tenants. The landlord is the owner of the property. The tenants, that is you, please make sure that your name is spelled 100% correctly on these lines. Unit type, please make sure that it is checked whether or not you'll be leasing an apartment, a townhouse, a duplex, a house, or a condominium. Below that, you will see equal monthly rent installments. Most of our leases are a certain number of set equal monthly rent installments. Some of them have prorated rents, and some of those would be listed below this, where it says prorated first month's rent and prorated last month's rent. Additional rent and fees are listed out in the next section. Security deposit, which is potentially refundable to you, is listed out on the bottom left box. Going back to the top right, you will see agent. That is us, Matchbox Realty Management Services, Inc. Below that is the address of the dwelling unit. Please confirm that this is the address of the property that you will be leasing. The next box down shows authorized occupants, and these will be allowed to live in the property so long as they are listed on the lease. The commencement date of the lease and then the termination date of the lease is listed here. Please note that these leases begin and end at noon on the date specified. Utility charges. Utility charges. Some leases will include utilities in the rent. Please make sure that those are checked here. Utilities tenant must obtain individually. Those are utilities that you will be responsible to obtain on your own. And then utilities provided by landlord and billed separately to tenant are utilities that we will provide, but we will put on your account throughout the term of your lease. All rent should be delivered to Matchbox Realty at 202 North Liberty Street. However, online payments are always encouraged. Page 2, supplemental provisions. If there are any supplemental provisions here, please read through them carefully. The applicability of Virginia law. This lease is supplemented by and is to be construed with and interpreted by the Code of Virginia as amended, and in particular the Virginia Residential Landlord-Tenant Act. Moving to page 3, section 1, agency. Matchbox is the authorized managing agent on behalf of the landlord and represents the landlord in this transaction. Section 2, lease term. Please see page 1 for the commencement and termination dates on your lease. Again, please note that each of these begins and ends at noon on the date specified. Section 3, rent. In accordance with the lease, rent means all money other than a security deposit owed or paid to landlord under this lease. Section 4, utility service. Please see page 1 for a summary of what would be included, not included, or you would need to obtain on your own in terms of utilities. Section 5, late fee. Rent is due by 5 p.m. on the 1st of each month and is late after 5 p.m. on the 1st. However, there is a grace period and we will not apply late fees until 5 p.m. on the 5th if there is still a balance. Section 6, insufficient funds. Landlord reserves the right to require that all monthly installments of rent be made by money order or certified funds. If there are any insufficient funds issues, then fees as spelled out will apply. Section 7, termination, renewal, and early lease termination. Either party may terminate the lease at the end of the initial term of this lease or at the end of any subsequent term by giving the other party written notice at least 60 days prior to the termination date of the lease. Section B, if landlord intends to change the terms or conditions of the lease, landlord will give tenants written notice no later than 75 days prior to the termination date, but which will be sent approximately 10 months in advance for student properties, advising tenants of the new terms and conditions of a renewal lease. If tenants fail to deliver to landlord a written election within 15 days from the date of the renewal notice of tenants' intentions to remain in the dwelling unit or vacate, then landlord may begin to remarket the dwelling unit at that time. Further, in the event the lease renews in accordance with Section 7A, then tenants shall be deemed to have agreed to the terms set forth in the renewal notice and the terms of landlord's then current form of lease, and shall be bound to such new terms until such time as the lease is terminated in accordance with this Section 7. Section C, except as stated in Section 32 of this lease, tenants shall have no right to terminate this lease for any reason prior to the expiration of the initial term. Section 8, security deposits. Landlord must return to tenants the security deposit as is required by law within 45 days after lease expiration and return of possession of the dwelling unit to landlord by tenants. In the event that damages to the dwelling unit exceed the amount of the security deposit and require the services of a third-party contractor, Landlord shall give written notice to the tenants advising them of that fact within the 45-day period. If landlord provides such notice, landlord shall have an additional 15-day period to provide an itemization of the damages and the cost of repairs. Section B, forwarding address. Tenants must provide landlord their forwarding address so that landlord can forward to tenants the security deposit disposition statement. Section C, multiple tenants. Landlord will draw one check payable to the tenant listed first alphabetically by last name on this lease. Section D, move-out inspection. Under the VRLTA, the landlord must make reasonable efforts to provide tenants with notice of a right to be present at the time of the move-out inspection. If tenant desires to be present, tenants must make a written request to landlord to be present at such an inspection, and landlord will notify tenants of the inspection times which must occur within 72 hours of the termination of the tenancy. Section E, set-off prohibited. Tenants have no right to deduct the security deposit from the rental payments for the last month of the term of this lease. Section F, landlord's successor obligated for security deposit. If landlord in any way transfers its interest in the premises, landlord will transfer the security deposit to the transferee. Landlord reserves the right to require a commercial insurance policy commonly known as damage insurance, but we do not currently require this. Section 9, move-in inspection report. Tenants will make an inspection of the dwelling unit, and tenants will agree that the dwelling unit is in a fit and habitable condition, except for such damages as have been itemized on a written move-in inspection report, a copy of which will be submitted by landlord to tenant within 5 days after the commencement date of the lease. The move-in inspection report will be deemed correct unless tenants object to it in writing within 5 days after landlord has provided same to tenants, and tenant's response must include photographs of any items to which tenants object. If this lease is an as-is lease, then tenants shall be required to submit to landlord a move-in inspection report within 5 days after the commencement date of the lease, including photographs of any items noted, which report shall be deemed correct unless landlord objects thereto within 5 days of receipt. Section 10, locks. Key locks may be rekeyed prior to tenants taking possession of the dwelling unit. Section 11, failure to permit possession. If landlord is unable to deliver possession of the dwelling unit to tenants on the commencement date of this lease through no fault of tenant, landlord shall not be liable to tenants for any damages other than to rebate any rent paid by tenants in advance and to return any security deposit which has been paid by tenants. If landlord cannot deliver possession of the dwelling unit or provide tenants with a dwelling unit within 15 days of the commencement date of this lease can be terminated by either landlord or tenants by the giving of notice as provided herein. Section 12, damages to dwelling unit. Excluding reasonable wear and tear, tenants will be charged for any damaged and or missing items based upon the actual cost of such repair or replacement. Section 13, animals. No animals of any kind will be allowed to be kept or maintained on the dwelling unit without landlord or agent's prior written consent and the execution of an addendum entitled Animal Addendum. Section 14, casualty damage. If the dwelling unit is damaged by fire or other casualty, by the failure of or malfunction of any equipment or utilities serving the dwelling unit, tenants shall promptly notify landlord and agent. Section 15, condemnation. If all or substantially part of the dwelling unit shall be acquired for any public use by the right of eminent domain, or private purchase in lieu of such right by a public body vested with the power of eminent domain, or otherwise acquired by a public body, this lease and all rights of tenants under it shall immediately terminate. Section 16, tenants' obligations. Tenants must personally use and occupy the dwelling unit only as a residence. Tenants must keep the dwelling unit in good, clean, safe, and sanitary conditions, comply with all applicable building and housing codes, use in a reasonable manner all utilities, services, facilities, appliances, and equipment. Use in a reasonable manner all electrical, plumbing, sanitary, heating, ventilating, air conditioning, and other fixtures and facilities in the dwelling unit. Change HVAC filters no less than every 30 days, and shall maintain such services at all times during the lease term. Tenants shall be responsible for any damage caused by their failure to comply with these requirements. Keep all appliances and equipment supplied by landlord in the dwelling unit in a good and clean condition. Not deliberately or negligently destroy, deface, damage, or impair any part of the dwelling unit or the premises, or permit any person to do so, whether known by tenants or not. Tenants shall give landlord prompt notice if any such damage occurs. Conduct themselves and require other persons in the dwelling unit to conduct themselves in a manner that will not disturb the peaceful enjoyment of others, nor that will harass others, and to behave in a courteous and respectful manner to others. Have the right to request in writing that landlord install a carbon monoxide detector in the dwelling unit, the cost of which may be charged to tenants in accordance with the VRLTA. Use reasonable efforts to maintain the dwelling unit in such a condition as to prevent the accumulation of moisture and the growth of mold, and to notify landlord in writing promptly of any moisture accumulation that occurs or if any visible evidence of mold discovered by tenants. Keep the dwelling unit free from insects and pests, and to promptly notify the landlord and agent of the existence of any insects or pests. Use reasonable care to prevent any dog or other animal from causing personal injuries to a third party in or around the dwelling unit. Not do any act which will increase the fire hazard or rate of fire insurance for the dwelling unit. Tenants and any other persons in or about the dwelling unit shall not engage in criminal activities. Tenants must otherwise comply with the statutory obligations imposed on tenants by the VRLTA. Section 17, landlord obligations. Upon written request of tenants in accordance with Section 16B VIII of this lease, install a carbon monoxide alarm in the dwelling unit within 90 days of such request. Comply with the duties imposed on landlords in the VRLTA. Certify that the smoke detectors located in the dwelling unit are in working order at the time of move-in and no more frequently than once every 12 months thereafter. Section 18, personal property of tenants. All personal property located in the dwelling unit, storage rooms, or in any other part of the landlord's property shall be at the sole risk of tenants or the parties owning the same, and landlords shall not be liable for the loss, destruction, theft of, or damage to such property. Tenants are required to secure renter's insurance policy. In the event tenants shall fail to acquire renter's insurance and provide the required certificate of insurance, or if the tenants allow any coverage to lapse during the term of this lease, landlord may secure a liability coverage which shall name the tenant as an insured and the premium for which shall be reimbursed to landlord with the next monthly installment of rent. Section 19, death of tenant. If a tenant who is the sole occupant of a dwelling unit dies, landlord may deal with the individual listed as the tenant's emergency contact in any landlord document regarding any matters related to the tenancy. Section 20, modifications and alterations. Tenants shall not make any physical alterations or changes to the dwelling unit without the express prior written consent of the landlord. Section 21, absence of tenants. Tenants must give landlord written notice of tenant's anticipated extended absence from the dwelling unit in excess of 7 days. Section 22, landlord's access to dwelling unit. Landlord, agent, and their authorized vendors shall have reasonable access to the dwelling unit for lawful purposes in order to inspect the dwelling unit, make necessary or agreed repairs, decorations, alterations, or improvements, supply necessary or agreed services, or exhibit the dwelling unit to prospective or actual purchasers, mortgagees, tenants, workmen, or contractors. Agent will give tenant at least 24 hours notice, unless impractical to do so, of routine maintenance to be performed that has not been requested by tenants. Landlord shall not be required to provide prior notice to tenants for any maintenance requested by tenants, and tenants shall be deemed to provide permission to agent and its authorized vendors to complete the work order. Any maintenance request by one tenant shall be deemed a maintenance request made by all tenants. Landlord may enter the dwelling unit without tenant's consent in cases of emergency. Tenants shall be responsible for paying the cost of any unnecessary service call requested by tenants, any service call resulting from damage caused by tenants beyond ordinary wear and tear, any costs incurred as a result of the tenants failing to keep scheduled appointments with service providers that require access in order to make scheduled repairs, or for failing to secure an animal at the time of scheduled repairs. If agent deems scheduling necessary, and tenants must coordinate scheduling a repair no later than 3 business days from the request, or sooner if necessitated by the nature of the request in agent's discretion. Section E. In the event there is a non-emergency property condition that requires tenants to temporarily vacate the dwelling unit to make the necessary repairs in the sole determination of landlord and or agent, the landlord or agent may require the tenant to temporarily vacate the dwelling unit at no expense or cost to tenant for a period of not more than 30 days to a comparable dwelling unit selected by landlord or at landlord's option to a hotel room. Tenant shall continue to be responsible for all rent due under the lease without abatement and shall comply with all other terms and conditions of the lease during any period of temporary relocation. Section 23, waivers. If landlord waives a noncompliance or breach of the lease or law by tenants, such waiver shall not be construed as a waiver of any subsequent breach of, noncompliance, or breach. This lease shall continue in full force and effect. Section 24. Action by landlord upon default by tenants. A. Discusses material noncompliance by tenants failing to pay rent when due. Section B. Discusses material noncompliance by tenants which can be remedied within 21 days. If tenants do not remedy the specified noncompliance within 21 days after receipt of such notice, then if such noncompliance is remediable, this lease will terminate 30 days after landlord has delivered tenants such notice. Section C has to do with repeat violations. If tenants have received a prior written notice that requires tenants to remedy a breach, and if the tenant repeats the prior breach, then this lease will terminate within 30 days for the reasons stated therein without allowing tenants an opportunity to remedy such subsequent breach. Section D deals with non-remediable violations or criminal acts. If tenants commit a material noncompliance that is not remediable, landlord may deliver tenants a termination written notice stating that this lease will terminate in 30 days. Section E deals with material noncompliance by tenants which can be remedied by repairs, cleaning, or replacement. If tenants commit a material noncompliance that can be remedied by repair, cleaning, or replacement, landlord shall deliver tenants written notice specifying the breach and stating that landlord, agent, or an authorized vendor will enter the dwelling unit and perform the work. Once the work is complete, landlord will charge tenants for such work, and such amounts are due as rent on the next rent due date. Or if this lease is terminated, immediate payment is due. Section F deals with remedies available to the landlord upon termination of the lease. Landlord shall be entitled to recover from tenants the following: 1. Rent due. 2. Other charges and fees. 3. Late charges. 4. Reasonable attorney's fees. 5. Cost of collections. 6. Cost of the proceeding as provided by law if a court action has been filed. Section G. Family abuse. If a tenant is a victim of family abuse as defined in the VRLTA, there are some ways that this lease can end. Section 25. Unlawful detainers. Acceptance of rent with reservation. Landlord may accept full or partial payment of all rent and receive an order of eviction from a court of competent jurisdiction pursuant to an unlawful detainer action filed under the provisions of the Code of Virginia and proceed with eviction, provided that the landlord has stated in a written notice to tenant that any and all amounts owed to the tenant by landlord, including payment of any rent, damages, money judgment, award of attorney's fees, cost of collection, and court costs, would be accepted with reservation and would not constitute a waiver of the landlord's right to evict tenants from the dwelling unit. Section 26, holdover status. If tenants remain in possession of the dwelling unit after the required departure date following the termination of this lease, tenants will be liable for the following damages sustained by landlord. 1. Landlord's actual damages, which include but are not limited to holdover rent equal to the per diem rent multiplied by the number of days tenants stay in possession of the dwelling unit after the vacating date, and storage, hotel, meals, mileage, etc. payable to the new tenant. 2. Liquidated damages equal to 150% of the per diem rent multiplied by the number of days tenants stay in possession of the dwelling unit after the vacating date. And 3. Reasonable attorney's fees and court costs. Section 27. Liability of landlord and agent. Landlord and agent shall only be liable to tenants for damages proximately caused by landlord's breach of the VRLTA or a specific provision of this lease. Section 28. Discrimination. Landlord does not discriminate against tenants in the provisions of services or in any other manner on the basis of any protected class under federal, state, or local fair housing law or regulations. Section 29. Rental application. The lease was entered into based upon the representations of tenants contained in the rental application. Section 30, financial responsibility. If the landlord is required to pay money or other consideration to tenants, tenants agree that such financial obligations will be satisfied solely from the landlord's estate and interest in the dwelling unit, or the proceeds thereof, so that landlord and agent will incur no individual liability for such financial obligations. Section 31, notice. All notices shall be given in accordance with the provisions of the VRLTA. Section 32, military. Section A. Any tenant who is a member of the Armed Forces of the United States or a member of the National Guard serving on full-time duty or as a civil service technician with the National Guard may, through the procedure detailed below, terminate the lease with landlord if the member 1. Has received permanent change of station orders, 2. Has received temporary duty orders in excess of 3 months' duration to depart 35 miles or more from the location of the dwelling unit, 3. Is discharged or released from active duty with the Armed Forces of the United States or from his full-time duty or technician status with the National Guard, or 4. Is ordered to report to government-supplied quarters, resulting in the forfeiture of basic allowance for quarters. Section D. Landlord reserves the right to require, as a condition of this lease, that tenants execute a waiver of all or part of the rights that the tenants may otherwise have under the Service Members Civil Relief Act. Section 33. Reasonable attorney's fees and cost of collection. If, as a result of tenants' noncompliance, landlord or agent engage an attorney, tenants agree to pay landlord's reasonable attorney's fees and costs in all courts of competent jurisdiction, as well as any other costs recoverable under Virginia law. Further, if landlord or agent engages a collections agent or in-house collections specialist, then tenants shall be required to pay all costs of collection as recoverable under Virginia law. Section 34. Rules and regulations. Tenants agree that the rules and regulations will be a part of this lease. Section 35. No smoking. Smoking is strictly prohibited, except in any areas specifically designated by landlord to be smoking areas with clearly marked signage. The term smoking means inhaling, exhaling, breathing, carrying, or possessing any lighted cigar, cigarette, pipe hookah, e-cigarette, vape pen, vaporizer, incense, or other tobacco or non-tobacco product or similar lighted or illuminated product in any manner or in any form, both legal and illegal, including both smoke and vapors. Section 36. Modifications and additions. This lease represents the entire agreement of landlord and tenant and may not be modified or amended except by written agreement of the parties. Section 37. Bankruptcy. Subject to the requirements of the Bankruptcy Code, in the event the tenant is adjudicated as bankrupt, this lease, at the option of the landlord, shall terminate upon 30 days written notice and the dwelling unit shall be surrendered to the landlord. Section 38. Waiver of homestead exemption. Tenants expressly waive the benefit of the homestead exemption laws of the Commonwealth of Virginia. Section 39. Tenant records. Tenants hereby authorize landlord and or agent to disclose and or release information contained in the tenant's files under the following circumstances. As set forth in the VRLTA, to the extent it is necessary for a third person to translate on behalf of a tenant, or to a guarantor under the lease. Section 40. Statutory notice to tenant. Tenants shall exercise whatever due diligence tenants deem necessary with respect to information concerning sex offenders. Section 41. Subordination. Tenants agree that this lease is subordinate to the lien of any existing or future deeds of trust or mortgages placed on the dwelling unit and premises, and tenants agree to execute whatever additional agreements may be required to so subordinate this lease. Section 42. Severability. If any provisions of this lease violate law or equity, the remaining provisions shall remain in full force and effect. Section 43. Wire fraud alert. Tenants are advised that crimes of fraudulent wire transfers may occur when erroneous wire instructions are provided by an unrelated third party, which, if used, can divert funds to the third party's account. Tenants are advised not to wire any funds without personally speaking with the intended recipient to confirm the routing number and account number. Section 44. Additional lease provisions. The following additional provisions apply to the lease if checked by the landlord: lead-based paint, noise zone or accident potential zone, defective drywall, asbestos. One addendum that you need to be aware of is the liability insurance addendum. In paragraph 1, this explains that tenants agree that agent will automatically enroll tenants in agent's liability insurance program. This policy will only cover the liability of the owner's property and will not cover any of your personal belongings and is not a substitute for renter's insurance. Rules and regulations.
Payments. The payment section of rules and regulations will give you details on when payments are due, preferred manners of paying rent, what late fees you may encounter, and basically anything that pertains to making a payment. It is important to note that Matchbox is not responsible for delays in mail delivery or the release of financial aid by any entity. Keys. In this portion, you will read about the criteria at which keys can be released at move-in, lockout services after hours, and lost or damaged keys. There is also information regarding copying of keys and what needs to happen if you change the locks on your home. Please be sure to read this thoroughly so you are aware of how this section pertains to you. Routine systems maintenance fee. Tenants shall pay a non-refundable fee in the amount stated at the beginning of the lease for routine maintenance, not related to your security deposit. Utilities. Tenant must have their utilities on during the entirety of their lease. This means through the last day of your lease. If you move out early and turn them off, you will be charged to reconnect the utilities, and if an appliance is damaged, you will be charged for the repair or replacement of that appliance. If you are residing in a property where your utilities are charged through Matchbox, the utilities will be placed on the account of the first person alphabetically by last name in the home. For communities where water is billed by Matchbox, there will be a minimum charge assessed for the usage of or below a predetermined amount, and additional fees may apply. The amount will vary by property and is subject to change without notice. Alterations. For some reason, this section scares people, but please know that we want you to make your Matchbox home a home. We don't want you to turn your walls into pincushions and leave the owners a mess to deal with after you move out. Be respectful of their property and do not use anything that will tear the drywall, leave large holes, adhesive residue, or greasy spots on the walls like what you would find after using poster putty. Take care of the wood floors by covering them with rugs and use felt pads underneath the legs of your furniture to prevent gouging. Information regarding satellite dish installation and cleaning and disinfecting of an apartment due to allergies will also be in this section. Maintenance. This list is long and vast, but comes from years of helping to mitigate maintenance issues. Please be sure to read through this list and come prepared with non-pleated air filters, a toilet plunger, and basic knowledge of the home that you are moving into. This maintenance section is standard to all communities, but some bullet points will only be applicable to certain communities. Please do not forget to read this section thoroughly. If in question, please ask your portfolio manager. Disturbances. All tenants have the right to quiet, peaceful enjoyment of their home. If you are found disrupting this right, this clause will explain the process in which you will be fined, warned, or have your lease terminated should you or your guests continue to disturb those around you. Occupancy. This section of the rules and regulations informs you about the decisions you make regarding all facets of occupancy. Definitions of party-free communities will be discussed, along with Airbnb rentals, actions of guests, and whose responsibility it is to secure roommates for your lease. Inspections and showings. This paragraph will give clear and concise information regarding inspections and showings of your property and the notice that we will give you should either of these be needed. If you deny access, there are financial penalties, and these are mentioned here as well. Move out. There is a menagerie of information in this section pertaining to your move out. Please read through this section and know that all sections may not be applicable. If you have questions in regards to your particular move out, please contact your portfolio manager and they can assist you with property-specific information. Parking and vehicles. These are very basic guidelines to adhere to in regards to parking. Please know that some properties may have their own parking regulations, and you will be notified of that as you pick up your keys and move in. Any changes in vehicles, status of ownership, and use of temporary vehicles must be communicated to your portfolio manager. Matchbox is not responsible for vehicles towed if not properly permitted. Renewal leases will require a new parking pass each year by August 31st. Prohibited items and trash. Please read through this section very carefully. Some items listed may seem like common sense, but others may surprise you. These prohibited items were created to protect the owner's property, keep you safe, and allow the community around you enjoyment of their surroundings. Other. There are a few miscellaneous items in this section that do not fall into the categories: communications from Matchbox, releasing of video footage, roommate disputes, guarantor qualifications, fines pertaining to lease violations, and more will be explained further in this section.
Thank you for choosing Matchbox.